Good morning, everyone, and welcome to the Ray Law International channel. I'm Anthony Ray, and I am here with Saki and Lauren for our monthly webinar talking about immigration, taking your questions and finding out what's on your mind and what's going on out there. So we have some awesome topics and situations that we're going to discuss today, but it's not all about us. We want to hear from you guys. Let us know where you're from and how you heard about us and what's going on. We also, of course, want to know a lot about not just the problems or issues you're having, but some of those success stories, where you got your green card or where you were naturalized recently. We want to hear some of the good stories out there as well. Again, if you don't know already, I'm the principal attorney at Ray Law International. We have our 3 offices in Chicago, Michigan, and New Jersey, where we service clients throughout the world. And feel free to reach out to us. Put your questions in the chat. And I am going to turn it over to Lauren.
Hello, my name is Lauren. I'm one of the attorneys here at Ray Law. Like Anthony said, if you have any questions specific to your case, feel free to put them in the chat. We may or may not be able to help. Obviously, if something's super specific, we're probably going to advise you to set up a consultation. And we'll have the contact information for how to set up a consultation as well on the screen. But more general questions or more general advice, we'd definitely be more than happy to help. And our topic today is family-based, but employment-based as well. We also do, so feel free to leave those comments in the chat. Saki?
Good morning from Chicago. My name is Saki, and I'm a legal assistant at the Ray Law International. Today's Chicago weather is really hot, 86, which is nice. Finally, it's summer. Yes, and then I'm going to speak Japanese a little bit. おはようございます。レイロインターナショナルの佐田池と申します。本日は、家族ベースですね、ファミリーベースでの、移民における様々な問題とその解決策に関してお話しさせていただきます。もしご質問等ございましたら、このライブストリームのチャットですね、日本語でも結構ですので、チャットでコメントいただければと思います。もしくはですね、今画面にも出てます、メールアドレス、もしくは電話番号の方に直接ご連絡いただいても結構ですので、どしどしご連絡お待ちしております。よろしくお願いいたします。Okay, so ready for today's topic? All right, let's start the first question. This question is to the Anthony. Anthony, I have a 2-year green card and did not file to renew because I divorced my husband. Do I have to refile a new green card application?
Well, that's a good question. And unfortunately, a lot of people find themselves in that situation. So basically, if you're not familiar, people who have a 2-year green card hold what's called a conditional green card. And that conditional green card is valid for 2 years. And before that 2 years, you've got to file a petition to remove that condition, get your full 10-year unrestricted green card. Now, in this scenario, we don't have all the facts, so I'm going to have to fill a few in. So if you divorce, you have to find another way to get a green card. Obviously, you don't just refile your green card because what basis do you have? You're no longer married to that U.S. citizen, for example, or even a green card holder. So what you want to look at is, do you qualify for one of the exceptions or waivers? There's the marriage in good faith exception or waiver, and then there is one where there's been some sort of abuse in the relationship. So if it's one of those, you can still get your green card, but you're going to need to do that within the time frame, okay? Never wait. All too often, we'll get the calls and people have waited. And we cannot stress enough, contact a professional immediately when the problems arise. When you start having marital problems and things are not looking positive, contact us immediately so that we can reach out to you and help. That's the time. You don't want to do it after it's already expired. So in this scenario, you have a 2-year green card, you didn't file to renew or file the I-751, and you're no longer married to the U.S. citizen. So under the rules, you're supposed to file 90 days prior to the expiration, but you didn't do that. So sometimes the government will give their discretion. So you could try to file a waiver showing that you got married in good faith and provide some exception as to why you did not file timely. All depends on the times and dates of your case. Or perhaps there was abuse or police reports. So you probably want to try to file that I-751 because you may not have any other alternative. You don't want to just sit and wait too long. Take action, move quickly, and people, don't procrastinate. That's the theme. That's the theme today. All right.
Okay, thank you, Anthony. Next question is to Lauren. All right, my daughter is a U.S. citizen and then threatened me saying she will call immigration on me. Should I be worried and can I do something about it?
Thank you, Saki, for that question. In this situation, I'm assuming this person is in the U.S. illegally. Unfortunately, if someone calls immigration on you, there really isn't anything you can do about it. However, you should know that immigration's priorities are criminal people or human traffickers, which I guess would be a crime. So if you don't really have an arrest record or something like that, likely nothing will happen, at least for a significant period of time, because you are a low priority to immigration. That being said, if this person is threatening you and abusing you and your daughter is a U.S. citizen, in that case, you may be able to file for VAWA, which is Violence Against Women Act, although it can be applied to men as well. If you have a U.S. citizen family member who is abusing you, potentially you can get a visa through that. The VAWA was created so that undocumented people aren't afraid to communicate with police or stay in some sort of relationship where they're being forced to do things just for fear of immigration being called on them. So, but definitely speak with an attorney if that's something that could apply to you. Saki?
All right, thank you, Lauren. I don't know today, like this side eye looks like I got beat up by someone, but I'm perfectly fine. Nothing happened. Just didn't sleep enough. Anyway.
Kickboxing?
No, I don't know. I wear the makeup, but I guess, it didn't work well. Anyway, next question to the Anthony. My daughter just finished the boot camp for the U.S. Army. Can I get the immigration benefit from this?
All right. Awesome question. We do have a question in the chat from Sammy. Sammy, we're going to get to you right after this. Either Lauren or I will touch on that. Great question, Sammy. We'll get to you in just a second. Thank you for putting that question there. But first, the question is, will you benefit from your U.S. citizen child going into the Army? So there's not going to be a direct benefit to the parent. So if your child goes into the United States military in one of the branches they qualify, you don't get the benefit directly or immediately. Now, your child obviously can go ahead through the U.S. military after service for a period of time to get certain benefits. They could qualify for a green card through the military. Now, several years ago, there was a program put together that just got all messed up. But the military, going to the military, providing service to our government, to the country, which is awesome. We love people that do that and protect us, So there is a way for them to get a green card. And then ultimately, once they get a green card and possibly citizenship after that, soon after, they then can benefit you as a parent. Okay. And that's the sweet thing of it. So in time, yes, not directly, because they have their military credentials or their service, or maybe they completed their service. That's awesome. But it's just going to take time. So what you want to do is reach out to an immigration attorney and plan accordingly. I can't stress it enough, people. If you just talk to a professional and plan in advance, a lot of your immigration woes and problems can be resolved. And it's going to make you feel better because at the end of the tunnel, there's light, there's hope. You're going to get your benefit. And we talk to so many people each week and help them put that plan together. And like this situation, there is hope, not a direct one, but ultimately, you'll get the U.S. citizenship. I always tell parents, treat that child very well because they're gonna need to help you out in the future as you try to adjust or change or resolve your immigration challenge. All right. So, Lauren, do you want me to take this one, the question? Or?
Sure, you can take it.
Okay, I'll take the first one. You take the next one. So go ahead and throw that question up there for Sammy. Sammy says, hello, I have a question. My children are U.S. citizens. I was deported. What are the chances of claiming me or filing I-90 form? I think it is considering my deportation and the health of their mom is really sick and I'm stuck in Mexico. So if anyone needs to, Lauren can probably summarize a little in Spanish if there's a need to, but I'm just going to give a real brief explanation. In this situation, when people are deported, they're going to need a waiver to get back in. Now, it also depends on why you were deported. If it's an immigration violation such as overstay of status or entered illegally, then you're going to need a waiver to come in to return or get the immigrant visa and then show a hardship to the U.S. citizen children. Now, in this question, I don't know if the mother is a U.S. citizen, if, of course, being married helps, but there's no indication that you're married to the children of the mother of your children. So I'm not sure. If you are married and your spouse is a U.S. citizen, then you can also use the hardship of your spouse as well. So there may be possibilities. It's a long road, so you want to get that I-130, the immigrant petition, filed or have your children filed if they're over 21 years old and start that process. If your spouse or the mother of the children, you get married, then, have your spouse filed. That'll be even... it could be even quicker, especially when you're showing the hardship waiver. The Form I-90 is not going to be applicable in this case. Basically, your children will be filing the immigrant petition on their behalf. Have your children call us and we'll help them and walk them through the process. And then once that's done, it'll go to the National Visa Center. They'll collect information. There's always a question of when to file the waiver, the 601 waiver, or even a 212 waiver. And that also needs to be approved. And then when you go for your immigrant visa, hopefully all the waivers are approved, you get your immigrant visa, and then you enter the U.S. Of course, there's going to be a lot of information. There's going to be a lot of information in... it's going to depend on the facts of your case. So if there's criminal issues or other things we don't know, that's the whole analysis. So I think Lauren's going to give a quick response in Espanol. Go ahead.
Okay. Hola, Sammy. Gracias por su pregunta. En este sentido, algunos factores que significa con su situación. De primero, si su esposa... la madre de sus hijos, de primero es su esposa y de segundo, ella es un ciudadano, ella se puede hacer una petición para usted y también un perdón para usted. Usted necesita un perdón para reentrar a los Estados Unidos después de una deportación. También depende cuántos años usted está fuera de los Estados Unidos después de su deportación. Posiblemente hay un par de 10 años, no sabemos, necesitamos posiblemente tener una pregunta sobre los hechos de su situación específicamente. El primer paso para usted para cualquier situación, si la madre de sus hijos es su esposa o no, es de hacer una petición I-130, eso es una petición de familia. Posiblemente sus hijos también pueden ser los peticionarios si ellos son o tienen más de 21 años de edad. No es afortunado que su esposa no tiene buena salud, pero con esto podemos posiblemente hacer un perdón diciendo que usted necesita ir a los Estados Unidos muy pronto para estar con su esposa o la madre de su hijo porque ella no tiene buena salud y podemos emitir evidencia de esto. Entonces, con esta situación muy importante, hablar con un abogado para asegurar quién es el mejor peticionario, sus hijos o posiblemente si es la esposa. También necesitamos hacer un perdón. Mi recomendación no hacerlo de su mismo. Es un poco difícil obtener una aprobación de un perdón. Y también toma mucho tiempo. Es muy importante tener un abogado en esta situación. Entonces, Sammy, por favor de llamarnos. En nuestra pantalla vamos a tener un número de teléfono para estar en contacto con nosotros. Está aquí. Si tenemos también WhatsApp, si usted está fuera de los Estados Unidos y no se puede llamar a nuestro número. Y para cualquier otra persona, yo hablo español, entonces preguntas en español también. Lo siento para mi español, que es un poco extraño, pero sí yo puedo comunicar para responder. Y si ustedes tienen otras preguntas, tenemos otras personas en nuestro bufete que hablan de manera muy fluente. Saki?
Thank you, Lauren. Next question is to Lauren, actually. My mom petitioned for me when I was 14 years old in 1996. Can I still benefit from the petition?
So the short answer to this is yes. Any petitions filed prior to 2001 can potentially benefit. Definitely talk to an attorney, but petitions such as this are eligible for a benefit called 245I. What that means is that even if you entered illegally to the US, in certain situations you will be able to adjust status and not have to leave the US or obtain a waiver. Now, if in this situation the mother is no longer living, in that case, this person would have to find a new petitioner. So say they have a spouse who's a US citizen or a child who is 21 years old. They still would be able to adjust status in the US potentially without leaving because they have this 245I protection from the mother, even though the mother may or may not still be living. So if you have a situation like this, even if it was, let's say, your uncle applied for your mother and you were a child at that time, so you would have been a benefactor to that petition because you were a minor and thus would have been a dependent to that petition. Potentially you can use that as well. So definitely speak to an attorney, talk to family, see if there is a situation like this. It could be very helpful in the future.
All right, thank you. So Anthony, related to this question, so what if I lost the approval notice of my mom's 1996 petition? How about this situation?
Absolutely. This question comes up so often. And, we have a few people who hold on to things and save it. But when people move or there's a fire or maybe an ex-spouse takes certain documents. We've heard it all. So one of the key things to remember is your immigration documents, no matter what they are very important. That's why at our firm we give you a scanned copy of everything we file so that you know what's going on. And we also have it on access. So stuff that's from 20 years ago, we probably have it. So give us a call and find out if there's old documents that you're missing or don't have. In this scenario, if the approval notice is lost, that is not an end to the whole process. What you can do, there's other factors, as long as maybe we have a receipt notice that we can pull off the status and show the USCIS that in case it was approved. We can also request a FOIA make a FOIA request. That's the Freedom of Information Act. Basically, you're asking the government to give us a copy of everything on record to get a copy of that. So if you don't have it, or if you lost it, or it's been destroyed or taken, or whatever it may be, there are several ways to get the document or to move forward. So that's why you hire a professional. That's what we do every day. Reach out to us. We're ready to help those people who may have lost it, maybe in a fire, moving, whatever it may be, or just can't find it. Yeah. So always hope.
Good to know. Okay, so the next question is to Lauren. I just married a U.S. citizen and I have a DACA. My attorney told me that I will need to leave the country to get the green card. Can I get the green card within the United States?
So first of all, I'll say that DACA, for those who don't know, is Deferred Action for Childhood Arrivals. So those are people who came to the U.S. or were brought to the U.S. as a child in certain situations prior to the age of 16, who are eligible for deferred action, which means that they don't have a status per se in the U.S. However, immigration has stated that they will not take action to deport them. They also get a work permit in this situation, kind of acknowledging that it was beyond their control that they came to the U.S. They were a child, so they have certain protections there. It's been really great for a lot of people to be able to work legally in the U.S. So in this situation, since that person came unlawfully into the U.S., well, potentially they were unlawfully, I guess I should say. If they entered the U.S. without inspection, meaning they didn't come through an airport or they didn't cross the border and talk to an official and then later overstay, this person would probably have to leave the U.S. and obtain a waiver once you are married to a U.S. citizen. The reason being is because of the unlawful entrance. Now, there is advanced parole for DACA recipients, which means that if you have an urgent need to travel outside of the U.S., you could potentially, definitely speak with an attorney. Do not do this on your own. You could potentially apply for a parole, which means that you would be able to leave and re-enter the U.S. still without any sort of status. Now, this can be very, very risky. I would not recommend doing this without an attorney. But if you do have an advanced parole and you re-enter the U.S., then you would have been inspected upon re-entering. So in that case, you would be able to adjust your status once you re-enter the U.S. So a couple things to think about. If you have DACA, but it's because you were brought here as a child and then overstayed whatever visa you were on because your parents kept you here, in that case, you would have been inspected, and perhaps you could show proof of your inspection. Maybe there's a stamp in your passport, you can show the visa, something like that. In that case, you would be able to adjust your status. So a few options. Definitely speak to an attorney. If you are not eligible to adjust status and you do adjust status, or you attempt to adjust status, I should say, that can create a lot of issues. We don't want that to happen. So speak to an attorney before you file anything.
Okay, thank you, Lauren. So the next question is to Anthony. I have worked in the United States without authorization. Will this prevent me from obtaining a green card through my U.S. citizen spouse or child?
Thank you, Saki, for that question. And, you know, this is one of the areas that I feel really passionate about in immigration. I really think that, even though we're penalizing people for unauthorized employment, we should really just let them work immediately. Why would you not want tax dollars or people to work? Most of the people who are coming, they're coming here to work and make a better life for themselves. So if you provide a path for them to do it legally, they're going to do it, and they want it because that's going to give them work authorization. They can move around, support their family, get the driver's license, and do other things that they need to. Also, mind you, it's easier to track these people. I mean, it makes so much more sense to give them work authorization. So logically, I don't know why we just don't give work authorizations to all the people out there who are illegal, because it would make the government's job a whole lot easier, and it would help out the nation overall. More tax dollars. But getting back to the question, I want to share my screen. I'm going to add this and put that on the screen. Now, as you see here, under the regulations, foreign nationals are not authorized to work in the United States unless they have permission. So if you came in the U.S. and you worked illegally, okay, that's the first thing. That's problematic. You're not supposed to do that, as you can see on the screen. You can't accept employment. Employers are not supposed to employ you. They're not supposed to pay you under the table. All that stuff is not supposed to happen. But in reality, they've got to eat. People, the government doesn't give them work authorization. So in reality, we just sort of have this blind fiction that we know you're working, but if we just can't prove it, or we're, it's okay, we're just going to let it slide, because everyone has to eat, live, pay rent, and survive when they're in the United States. Now, the good news is, for those individuals who has a U.S. citizen spouse or a U.S. citizen child over the age of 21, when they go through the green card process, unauthorized employment is forgiven. And as you can see here on the screen, immediate relatives, that's what we're talking about. Who are the immediate relatives? That's your spouse, your children, and your parents, okay? So spouse, children, parents, those are immediate relatives. There's several other categories that you can see listed here. So feel free to take a look at that. There's other exceptions, but really what you want to do is speak with an attorney, make sure you meet all the requirements, and there's nothing else out there that may cause you problems or issues as you go through the green card process. So the answer to that is no, it will not prevent you from getting a green card. However, we've got to check all the facts. There may be something else out there, okay?
All right, thank you, Anthony. Next question is to Lauren. I used the made-up social security number and a name in the past. Will this prevent me from obtaining a green card?
So the answer to this will depend on who is petitioning for you. If a family member is petitioning for you, technically this will not impact your application. Well, potentially. Using another social security number is what USCIS would consider a bad moral choice. So you will have to provide a lot of evidence showing that you are actually a really good person, right? You're involved in your community, your children's lives, you pay your taxes, you just have this one thing that you've done. The other thing is you have to be really sure that, is that social security number a US citizen social security number? We really don't want you to be dinged by immigration saying you were claiming to be a US citizen by using this number. So that's another thing to be aware of. But if this is a fake number, or if you're using a permanent residence number, for whatever reason, it's not a bar to adjustment, just if it's U.S. citizen. So you will need, some other forms of good moral character evidence to combat that. Definitely get an attorney so we can prepare you for how to answer questions. You will be asked questions about this. However, we have helped people receive green cards who have done this in the past. So it is not a bar to adjustment in some circumstances. Saki?
All right, thank you, Lauren. So it is 10:30 now. If everyone knows what that means a little coffee break time. So today's question is, what is an embarrassing situation you have been in? Anthony?
Well, it's not 10:30 over here, so I wish it was 10:30. But anyways, just joking. It all depends on where you're at with different time zones. That's the joy of working in various time zones and with people around the world. Just a quick note before I give an answer to this. For Sammy, always go back and review. You can play this back at the end and just go over that section, the first half of it, so you can hear our answer. You can also reach out to us. Vladimir's waiting. You can call him now at the numbers that is going to be on the screen. If someone will put that on the screen, go ahead and reach out to us through those means. Probably best to email or call when you get a chance, and Vladimir will help you in English or in Spanish. So now I was thinking about this question, and I don't know if it's really embarrassing. I guess for some people it'll be embarrassing, but for me, I handle these situations a little bit different. I don't turn red or I don't feel ashamed. It's just sort of the things that you have to deal or go through life. We all make mistakes. So in middle school, here in Michigan, I think in our middle school we had 7th and 8th grade, maybe 6th, 7th, and 8th grade. And so during that period of time, I happened to be on the National Honor Society. And one of the privileges of being on the National Honor Society was giving announcements to the whole school, right? And so, the teacher in charge would pick a few of the people on the National Honor Society to give out announcements. So I had the privilege of doing that. And in all my wisdom and everything, I was giving my announcements. I was confident and telling the whole school what was going on and the updates. And there was one word that, unfortunately, I wasn't familiar with. And so it had to do with sports. And instead of saying rival, I said rival. And a lot of my, I wouldn't say a lot of my schoolmates, they laughed about it or, told me about it. But the teacher in charge, I don't even know if she's still alive or not. But anyways, hopefully she's not watching this recording. Anyway, she was so frustrated. She's like, you're on the National Honor Society. We don't make mistakes and all this high standard. And I'm like, really? It's not that serious. Everyone actually knew what the word was. It's rival. I just mispronounced it. So in a sense, that's sort of embarrassing. But then also, you're in school, you're supposed to teach people. So it's a learning experience from my standpoint rather than something totally embarrassing. I don't remember anyone, reminding me years or at graduation from high school that I made that mistake. But that's one of the things that I guess could be considered embarrassing. And that happened when I was in middle school. So that's sort of my story of an embarrassing situation.
Nice. How about you, Lauren?
I want to hear Saki's. I guess mine would be, I didn't eat a lot of meat growing up. So one time I was at a restaurant and I ordered a ribeye and I thought it was a fish. So they asked me how I wanted it cooked and I was really confused and said grilled. So they had to explain that it was beef. But now I eat a little bit more meat, so I know. The end. Sorry.
Oh gosh, I was hoping that you don't ask me. I have many because, I'm from Japan, and then once I come to United States, totally different culture. I was explained to people I'm like a bear Paddington, like it just came from the jungle, didn't know the rules, and I make a mistake. So one of it was like a first time I came in the US and I couldn't speak English that much. I was in high school as an exchange student, and I was invited for the someone's baby shower party. And then in Japan, we don't have baby showers, so I didn't even know what that means. Like, what is a baby shower? So, and it seems like everyone else knew what that was, and I thought like that'd be too shame to ask. It's like too general question to ask. So I didn't ask, and I just assumed like, okay, it's a baby shower, so it should be a cute thing. It should be a cute fun party. So and then they told me that I need to get the gift for the baby shower and bring it. So I got the gift and I went to the party. And first of all, there's no baby. I didn't even know baby shower was before the baby was born. Uh, so I was like so confused myself, and also like, so there's no baby, so I'm not gonna watch the baby taking shower. And then I was like, that's the issue because the gift I got was the little rubber duck. Because like I was like, baby showers, what's the best gift? Rubber duck for the bathtub? I don't know. So that's what I brought, the rubber duck. And then later the party, I learned everything what the baby shower is. But yeah, it's like a huge culture shock moment. Not shock, but like a different culture that I learned. But sometimes tough to learn. So that was my story. Okay. All right. So next question. Let's move to the next question. This question is to Anthony. Okay. I falsely told an immigration officer that I was a US citizen in 2002. I was also a victim of the armed robbery. I was told I could not get the green card through my US citizen son because of what I did in 2002. Is there any other way to get the green card?
All right. So there's a lot to unpack here, folks, and I'm going to share my screen. One of the things, in a second, I'm going to share my screen and pull up some information for you guys to look at. But one of the things you never do, it is like the ultimate sin, it's the ultimate evil thing in immigration, is to claim to be a U.S. citizen when you're not, okay? Whether that is as a green card holder or before you become a green card holder, if you're not a U.S. citizen, never claim. Don't check a box on an application. Don't register to vote. Don't try to get a U.S. passport. Whatever it is, don't use someone else's birth certificate who's a U.S. citizen. That is the ultimate sin or crime in immigration. Why is that the ultimate crime? Because that's your ultimate goal. We just talked about people trying to get citizenship, and if you claim to be something you're not a person of good moral character, and the government says we just don't want you. And for the most part, there's no exceptions. So if you claim to be a U.S. citizen and you have a U.S. citizen child or spouse, or maybe you're a victim of the robbery and you apply for a U visa, that is always going to be with you and be a stumbling block. Now, there's a few narrow exceptions, which I'm going to share on the screen right now. Just a moment. Let me get that up there. This is off the USCIS website. You guys can check it out for yourselves, get some more information. But some of the exceptions only apply to those who appear to be in refugee or asylee status. So if you're not an asylee or refugee status, you may not have or qualify for a waiver from claiming to be a U.S. citizen. So any false claims of being a U.S. citizen, just don't do it. And this is where a professional comes in and helps you so much. Often when you come from another country, you don't know the rules and the impacts of your decisions here in the United States. And these are life-changing situations if you claim to be a U.S. citizen and you're not. So, you really want to avoid this at all costs. So speaking with an immigration attorney, someone who cares about you, really wants to see you to be successful in immigration, we're going to make sure that you don't fall into this pitfall. So to answer this question, is there any other way to get a green card? Most likely not. Okay, there are a couple exceptions. Most waivers, the 601 won't help because they don't rectify or solve the issue of false claims to be a U.S. citizen. Unfortunately, it's really sad when we see people in that situation. And unfortunately, there's often it'll be in a police report or FBI report where someone tried to use a U.S. citizen passport to enter the U.S. or a U.S. citizen's birth certificate to enter the United States, and it's not theirs. And now, they've just lost an opportunity for a lifetime. Again, there are exceptions, as we mentioned and showed on the screen. However, those are going to be far and few between. So, Saki, go ahead. Give me the next one, all right?
All right. Next question to Anthony again. All right. A friend was told that she could not get the green card because she entered unlawfully multiple times. I entered unlawfully 3 times. 3 times only? In 1993. Will I also be unable to get the green card?
Thank you, Saki, for that question. So, multiple entries into the United States really does negatively impact your chances of moving forward. There are exceptions, okay? And laws change. Immigration laws are changing almost monthly. So don't give up hope. But on the surface of things, basically, if we just look at these minimum facts that we have here, the multiple entries are not going to allow you to get a green card. Now, why is that? First, when you are here unlawfully and then you stay here for over a year or 6 months, then you're going to be subject to a bar, okay, an automatic bar. And then when you leave, that's triggered, and if you come back in illegally again, there's no justification. And what the government is saying is, hey, you didn't obey and follow our laws in the first place. We'll give you one exception. Maybe you can get a waiver if you have a one-time entry or one-time immigration violation. But when you repeatedly violate our immigration laws, no, we don't want you, unfortunately. It doesn't matter, the love of your life is dying, cancer, whatever it may be. The government doesn't care. People who repeatedly violate our immigration laws get a stricter penalty. Now, are there some exceptions? Yes, there may be. However, it's going to depend on the facts of your case. And the only way to analyze that and see if you qualify for some of those narrow exceptions is to dig deep into your case, get all the facts. I encourage people, write down your immigration history in detail, whether that's in English or in Spanish, get it to us so we know all the details. When did you enter the U.S.? When did you leave? How many times? Were you inspected? Were you caught at the border? Were you turned back and then re-entered? All these things we look at. Are there any criminal backgrounds? In criminal history or any other violation, domestic violence. There was an article I was just looking at getting prepared today, and there was one of the baseball players. I don't know if he's a U.S. citizen or not, but he was restricted from playing baseball because of some marital issues, and oftentimes that domestic violence. So I often tell our foreign nationals and people who are not yet citizens, U.S. citizens, is you have to be stellar citizens in the U.S. Okay, not U.S. citizens, but stellar citizens or people in the U.S. You cannot make mistakes. You have to be even better than the U.S. citizens who are here. Because us U.S. citizens, we can make a mistake. We're not going to get kicked out of the U.S. But if you guys make a mistake, you could be on the ship out the U.S. or have no possibility of correcting your immigration situation. And you don't know how many people I've talked to who are 65, 70, 80, and they're trying to still correct their immigration situation, and they just can't. And they have no Social Security, no medical benefits, and it's just a sad situation. So get in touch with an immigration attorney. Most likely, if there's multiple entries, no, you're not going to benefit. However, we can help see if there's any of those exceptions that may be applicable in your situation.
All right. Thank you, Anthony. All right. Next question is to Lauren. I entered the country with a B2 visa in 2002, overstayed, and never left the US. Can my US citizen son still petition for me and get me a green card?
Yes, the answer to this is yes. Since you were inspected when you entered either at the border or at the airport using your V2 visa, you would not need to leave the US and get a waiver in order to adjust your status in the US. Now, if you have some other crimes or something like that, that may be a bar to getting your green card, but assuming that you have no crimes or issues, yes, you should be able to get a green card once your US citizen son turns 21 years old.
Thank you. All right, next question is to Anthony. I entered the country unlawfully in 2002 to visit my green card holding mother and never left the US. I still live with my mother in the US. Can my US citizen son still petition for me and get the green card?
As with all questions, it depends. It depends on a few more facts that we need. If your U.S. citizen son is under the age of 21, no, you can't. You have to wait. The fact of the mother being a green card holder does not help you really too much. Now, could your mother, who's a green card holder, petition for you? It all depends on whether you're married or single. So there's a few more facts we need. So I'll just go through the scenario. For your mother to petition for you, you would need, and depending on your age, if you're still a dependent under 21, then yes, your green card mother could petition for you. If you're older, she could also petition for you. However, if you're married, she could not. Okay, but remember, in that category, if you're married, if you're over 21 and not married, the waiting period, it can take years, okay, depending on what country you're from as well. We don't know what country you're from, so it also depends on the country. So there's all these little details that we as attorneys know and pull together to analyze and figure out the situation of whether you can petition. So in this scenario, basically, the green card holder mother is not really relevant and shouldn't be all that helpful in this situation. Now, for the child, if the child is over 21, yes, they can petition for you. However, you should be fine in that situation. Remember, we talked about immediate relatives. In that previous slide, we talked about unauthorized employment. In this situation, we're talking about unauthorized stay in the U.S. or overstay of status. In this case, in this scenario, the person overstayed their status, so they would be able to still adjust status because they have an immediate relative, their child, U.S. citizen child, and get a green card. And it appears to be no other violation. Okay, so remember, if you are married to a U.S. citizen, or have parents or a child, their immediate relative, and that allows for them to petition and allows you to adjust status, even if you have unauthorized employment or overstay of status. Okay, the key is you have to come in legally. Okay, let me see. I entered the country. Sorry guys, in this situation, unlawfully entered. So you're going to need a waiver in this situation. The 601A waiver may not apply because it's a child. You probably should encourage your mother to become a U.S. citizen. And then that would allow for you to possibly go ahead and do a 601A waiver and then come into the United States. Sorry guys, I didn't catch that one detail of unlawfully entering in 2002. But there's always options. So let us know. Take it away, Saki.
All right, thank you, Anthony. So the next question is to Lauren. I'm a green card holder and want to vote as soon as possible. Yay. Okay, I have been married to my US citizen spouse for 2 years. Can I naturalize before the 5-year wait?
In this situation, yes, you can. People who are married, who obtain their green cards through marriage to a U.S. citizen, do not have to wait the full 5 years. They just have to wait 3 years. And you can apply even a bit before the 3 years, as long as you are going to reach those 3 years. I think it's within 90 days, but double check that, prior to filing. So yes, you can absolutely get a little bit of a head start on your naturalization application, and get your citizenship a little bit early. Saki?
Oh, that was a quick answer. All right, the next question is to Anthony. I have a family court order granting me custody over my 8-year-old non-citizen nephew due to abandonment by his parents. I was told I could not petition for him because of Hague Convention complications. Is there another way to get him a green card?
Yes, there is a way to do this. The question's a little complicated because we need a lot more facts. I would like to see, why under the Hague Convention, what those complications are. Us as attorneys, we love complicated things, and that would be something we would look at. Setting the Hague Convention aside and the age of the child, and assuming, again, we're making a lot of assumptions here, assuming that the person who's speaking is a U.S. citizen, okay? If you go and adopt a child at this age, 8 years old, there should be no reason for you to go through the process, file a petition, bring them in, and if you're a U.S. citizen, as soon as they enter the United States, they become a U.S. citizen as well. Now, Lauren can help me out or also chime in if there's something I'm missing on this one, but there's, the Hague Convention, as you know, only applies to certain countries, okay? So I don't know if the complications are procedurally, something went wrong, or the parents, I'm assuming they're U.S. citizen parents, that didn't work out. Or if they're not in the Hague Convention, it's probably even easier. We've had older siblings, sponsor or adopt their younger siblings and bring them in with no problem, irrespective of the Hague Convention complications. So I don't think that there's any reason why we just can't file an I-130 and bring them in. Anything you want to add to that, Lauren? Or maybe I'm missing something?
I don't have anything to add. No, I thought that was a good synopsis.
Yeah.
Definitely talk to an attorney is always our answer, because especially adoption, the Hague Convention, who's ever heard of the Hague Convention besides adoption or immigration attorneys? It can get really complicated. Just because a family court says something does not mean that for immigration purposes, it's actually going to help you. So even if you think, oh, this person's a judge, they don't probably have knowledge of immigration. So, we've had it happen before. Definitely speak with an attorney.
Yeah, when we get to this level of immigration questions, we're really getting into the minutia, the details of the law, and it's not as interesting for everyday people. People just want to know, hey, how do I bring them in? And we'll do all the digging and all the hard work, but feel free to reach out to us if you're in a situation where you're adopting a family member, a relative, nephew in this similar situation. We'd be more than happy to do that.
Okay. All right. So I guess we can do one more questions. Last question is to Lauren. My father petitioned for me in 1996, and then the priority date became current in 2021. He passed away in 2022 while I was in the United States. I have no children or spouse to petition for me. Can I still get the green card?
So the answer to this is maybe. As always, contact an immigration attorney. But it sounds in this case like, yes, you would be able to. However, in any situation like this, you're still going to have to find a new sponsor. So if you do not have any family members who are U.S. citizens who would be a sponsor for you in place of your father, you'll need to find a friend or some other person who will take that place for you and fill out that I-864. So there could be some issues with that. Every situation is going to be different. So definitely speak with an attorney if this is something that may apply to you.
Okay. Well, that was a quick answer. I guess we can go one more question. The question to Anthony. I came to the United States in 1955. I lived in the United States believing I was a U.S. citizen, but it turns out I am here unlawfully. I have no family in the U.S. anymore, and I have not been a victim of the crime. Can I still get the green card?
This is a very interesting scenario. I haven't seen this in a while. Again, we need a lot more facts because that could impact, how we answer this question. It's going to be tough, but, there may be some exceptions. One, because in 1955, the immigration laws were very different. And I apologize, I didn't go back and research this specifically to see if there's some certain exceptions for people that early on. But generally speaking, you would need to have a petitioner or sponsor, whether that's an employer or family base, or there were certain special circumstances, such as maybe you were a victim of a crime or a special immigrant. So there may be other avenues or exceptions that you may fit under in this situation. I don't know how, since 1955, you wouldn't know whether you're here legally or not. Sometimes early on, people did get Social Security numbers, but, obviously, when you applied for a passport, you would find out something was going on. Or if, a lot of the states right now, a lot of them require the renewal of your driver's licenses to show that you are here lawfully, or if you are not here lawfully, to show that you're a resident. So, since 1955, this should have came up, or there should have been some discussions you should have had to see if there's some other avenue. Again, if you don't have a family or an employer to sponsor you, it's going to be really, really tough. And if you came in unlawfully, the nice thing about it is you may not be under the very restrictive laws of the 1997 IRA, which is good. So there's going to probably be some options for you. After 1997, if you entered, it's just you're out of luck. It's just really bad. So we would have to dig a little bit deeper into the laws back in 1955 and see if, in fact, there is some exceptions or way for you to adjust status. But again, you're probably still going to need an immigrant petition, whether through an employer or family member. All right. So, Saki, any other questions you have for us? Are we wrapping up?
We're good to go.
All right. So, everyone, I want to thank you for joining us today. Hopefully some of this information was helpful. We did have Sammy who asked some questions. Again, we're here to help you guys out, not just give you information. Your case is special. You have particular facts that are unique to you. So we want to hear from you. Reach out to us at the number or the email at the bottom of the screen so that we can help and make a difference in your life and of those around you. If you know other people who have immigration situations or challenges, we're here to help them out. So please pass them along, tell them about this channel, check out our other videos on our YouTube channel. We have over 300 videos on pretty much every immigration topic out there. If you don't see something that you want to know about, put it in the chat, reach out to us. We always monitor our social media to see, what people are looking for and what they like. So on behalf of our team here, we want to thank you. You guys have a great summer. We'll see you next time on July 20th in the middle of summer. Hopefully everyone's enjoying their vacations. And you guys have a wonderful summer. We'll see you next time.